I would like to start from a very brief overview of the major aspects of what types of law do we have, what legal instrument are we using, and what type of processes are we have in Europe. So starting from the beginning, what types of EU law we have in EU? So we have a primary legislation in form of governing treaties, so two treaties that are deciding on how the European Union function and what are the main issues that are important for the first. Then we have a secondary legislation, which would be which could have a form of binding regulation, directives, or decision, or non-binding opinions and recommendation. And then the third part of EU law is a case law, so the judgment by the European Court of Justice and General Court. Then we have a legal instrument in a little more details. So the regulation are so the regulation which are binding in the entirety and directly applicable to the member states. So there's not really need, it's only need for translation to the official languages, and they are becoming a law. Then we have a directives which are binding for member states as to the objective they have to achieve, which has to be transposed to the legal system of the member states. Then we have decisions which are fully binding on those to whom they are addressed. And then we have recommendation and opinions. As I mentioned, they are not binding. We will need those legal instruments to understand better the level 2, because those legal instruments, if they are taken under the ordinary legislative procedure or special legislative procedure, that will form the framework for the delegated acts. So here a little bit more about the legislative procedures. So the legislative powers are in the treaties. So the treaty provision is going to tell what are actually the legal base that prescribes on what type of legislation procedure and is to be adopted. And we can say that we have three main legislative procedure. One is the ordinary legislative procedure, which is the main legislative procedure of the European Union. More than 80% of all legislation is currently undertaken by this procedure. And it's a European Commission is proposing a draft, which is later discussed and agreed by the co-legislator, which are Council and the Parliament. Then we have a special legislative procedure, which can have two forms: consultation or consent procedure, which is adopted by the Council only after consultation and consent of the European Parliament. It's as it shows that the Council is in the dominant position in this one, it's usually not the favorable one, but there are certain articles that require this type of procedure. And then we have a delegated or executive legislative procedure that was added by the two articles of the Lisbon Treaty and is right now a founding for the delegation of powers. So we can say about the delegated acts from that. So this is the slide that just shows the ordinary legislative procedure, and today we will concentrate on the last dot of the black thing, which is the level 2. So as you can see, how complex the EU legislative procedure is, and right now, because of the changes in the treaty, we added a little bit more complexity to the whole.
But it's clear, I mean, in this graph, I think we got quite of the big step, so it's a very visual way, I think, to look at this complex family. Could we say that it has become more complex in recent decades or not, briefly?
Well, the whole, this is a good question, because the whole issue about having the delegated acts, it was about transparency and speed and bigger democratic scrutiny. And I think it's just confused a lot of people, because it was just not sure how they should act, and the institution weren't really sure what their new role is and what they actually do. So it's still very vague, but I think at this point of time we everybody, both the participants and the institutions, are a little bit more aware of what is expected from them and how the delegated acts, non-legislative acts, are being formed.
All right.
So now, just because Finance Watch is very concentrate on the financial services and the
Yes.
financial legislation, I would like to just go with a brief overview about how the how the financial services legislation actually shaped. So we have to start from 2001, from the high-level expert group that was chaired by Baron Lamfalussy, that established a special regulation, a special legislative process for the securities sector. The aim of that process was just to use the expertise of the national supervisors to make it to allow for more speed and expertise of people that are facing day-to-day issues with the financial regulation. In 2004, the Lamfalussy process was extended for another sector, so banking and insurance. And then we had this also by the two additional sectors that use the member states in form of committees that help them to create the appropriate legislative.
But then hit the crisis, right? Then what happened afterwards? Can we see any change?
Yes. When the crisis, it was before it was said that this cooperation and the implementing measures that were non-binding were enough to make the cross-border the operation of cross-border institutions safer. But after the crisis, it was said that it's not enough. So the guidelines and implementing measures to coordinate supervisions were not enough. Therefore, in 2009. The final report on financial supervision in EU that was prepared by the high-level expert group chaired by Mr. de la Rosière gave certain recommendation to the Commission on creation of the financial supervision in the EU. It proposed creation of European system of financial supervision by creating the European Systemic Risk Board for the macroprudential oversight and replacing the level 3 committees from Lamfalussy process with European Supervisory Authorities, so-called ESAs.
But you know, there is something like we hear about committees and there is level 2 and level 3 and all this. I mean, is that a bit confusing at the end? Can you do something about this?
I think it's very much confusing, especially if we are referring to the Lamfalussy process before the 2009 and to the current process for the financial services legislation. Because as you can see from the old Lamfalussy process, we have a level 1, which is responsible for establishing the framework regulation. So there are 3 main institutions, so Council, Commission, and Parliament. And then we have a level 2. And level 2 are those European Banking Committee, the European Insurance Occupational Pension Committee, European Supervisory Securities Committee. And all those committees were the supportive committees for the establishing of the level 1 legislation, but they were created from the representatives from the member states. And then we have a committees, so-called level 3 committees, which was the CEPS, CEOPS, and CESAR, that were after 2009, after the recommendation from the La Rosière report, changed into the European Supervisory Authorities. And then the whole power and possibilities change about the decision-making process. So now we have the Lamfalussy process after the post-Lisbon, so post-2009, because it also can be confusing because the Lisbon Treaty added the 2 articles that we are going to talk a little bit later, the 290 and 291. But then we also created the European Supervisory Authorities, which right now lead certain functions for the establishment of the legislation in financial services. So a very brief overview about the post-Lisbon or post-2009 process in financial services. So we still have the level 1, which is the framework legislation, directive or regulation, which is proposed by the Commission and adopted by the Council. This regulation can delegate to the Commission certain measures. So now we are talking about the level 2, the delegation of certain powers, which is in the framework legislation, to the Commission. It's the delegation of it's the delegation to create the acts. So we have the Commission can be tasked in drafting the delegated acts, in implementing acts, and the ESA can be tasked in drafting the binding technical standards. If it's confusing at this point, no worries, because we're just going to explain it
it's very clear
in a little bit more, with a more confusing way on the further slides. So, but the level 2 are the specific provisions that are delegated under framework legislation based on Article 290 and 291 of the treaty to the Commission to adopt non-legislative acts. And then we have a level 3. Sorry.
Yep.
So we have level 3, which is that ESAs are advising the Commission in preparing the level 2 measures. The European supervisory authorities also consult with relevant stakeholders. They also are tasked with the creation of the single rule book. They have a new tool that is the question and answer that can everybody can submit the question to make the convergence tool to promote a common supervisory approach. And then we have a level 4, which is enforcement and compliance. So EC, as a guardian of the treaties, can check with cooperation with member states and the European regulatory authorities if the law is applied consistently, or if there has been any breach. So they can also investigate the breach of the law. So then we can go into more detail to what is level 2 and how to divide the level 2. So
now we get into more details. That's what you're going to.
Yes.
No, yeah, great.
That's correct. So the framework legislation has to specify the procedure under which the delegated power is granted to the European Commission. So this is important to note that always in the framework legislation the delegation has to be stated clearly. And then I think it will be easier to understand how to divide the level 2s and into binding technical standards and other technical measures. Because the draftings are, the treaty base is always the same. So the treaty base is always 290 or 291 article of the Treaty of Functioning of the European Union. However, the people that are tasked with the primary responsibility for drafting are different. So if we're talking about the binding technical standards, the framework legislation specifies that it's the ESAs that are responsible to provide the first draft. And in the other technical measure in form of delegated acts or the implementing acts, it would be the Commission. What is important to notice, there are different control mechanisms, and there are also different functions that both the binding technical standards and the delegated and implementing acts are fulfilling. But the most important part is that it's always the Commission that is responsible for adoption. The ESAs don't have the power to adopt anything because they are bound by the Meroni doctrine that says that only the Commission has the power. And basically the adoption is.
But when do you choose between delegated act or implementing act?
Well, it's a good question because we have this is actually very vague. There are some guidelines in when the delegated act and when the implementing act should be used. For example, that the Commission, the Council and Parliament can delegate the power to the Commission in the framework legislation if they only regulate certain field partially. So they leave a lot of responsibility to develop supplementing acts to the Commission. So the supplementing measure has to be developed by the Commission. And then with the implementing act, which is responsible for the harmonized interpretation of the directive, it might be stated that the European Parliament and the Council would like to see the harmonized implementation of certain issue, and that's why. But maybe to go back to the basic, what is being delegated, because this is very important. So the easiest say, the delegated is the power to legislate. Because as you probably know, only the Parliament and the Council share the legislative powers. The Commission doesn't have the power. So the Parliament and the Council may decide that because it would be faster and it would some other, the Commission will have more technical expertise, it would be better that they are responsible for preparing the non-legislative act. And then we have, but everything, every delegation is always included in the framework one legislation. It's very important to remember that it can be on the scope, it can be on, there can be put certain limitation on delegation of power. For example, the material limits when the Commission can also amend part of the text or the temporary by the sunset clause that the delegation will last only for short period of time.
All right.
So now we have a comparison of delegated versus implementing acts. So it gives you an overview of what is actually delegated acts and what is implementing act and what are the main issues. So maybe we can just go very fast.
I mean, it will be recorded anyway, so later on, if you want to come back,
yes,
it will be on our website.
So maybe I just go through the things that I think are important to distinguish between the delegated act and implementing act. So the main difference between the delegated and implementing act is only the Commission can adopt the delegated act, while it could be also in certain cases, in very justified cases, that in case of implementing act, is the Council that can also adopt the act. It's a question of if it's good or not good, and what was the rationale behind that. But some people claim that because of the harmonization is applicable to the member state, and the harmonized implementation is important. That's why the Council should have the last word. As I said before, the limits of the delegation are set in advance in the legislative act for delegating act, while the limits of implementing powers are established subsequently in the form of the comitology procedure. So with case of delegated act, it's always on case-by-case basis when the Council and the Parliament are talking if there is a need for delegation, while with the implementing act, there is a regulation of the European Parliament and the Council which sets the rules for general principles for the comitology procedure. And then I think this is very important, and it's always sometimes used as a trade-off to when we are talking when the co-legislator would like to use delegated or implementing acts, is that the power of revocation. So with a delegated act, the Council and the Parliament has the power to veto or revoke the revocation. They can do it by absolute majority in case of the Parliament and by the qualified majority in case of the Council. So this is the additional scrutiny that is being applied to the delegated act. while implementing act after adoption, after adoption by the Commission, it can be scrutinized by the member state, while the co-legislator have very limited power to influence. Yes, so I believe that those are the major issues about the
Great.
Delegated and Implementing Act. So now we have a binding technical standards. So
That's she's feeling better there.
yes, we almost have done. So binding technical standards. With establishing the European supervisory authorities, the Commission, the Framework 1 legislation can also delegate the power to the Commission to adopt technical standards that are being prepared by the European supervisory authorities as the bodies that are having the technical knowledge, and they are very close to the supervised market, so to the financial sector, that have a better understanding of what is needed and how to be efficient. And the level 2, in form of binding technical standards, can only apply to technical matters, and so there should be no strategic choices or policy choices, and the wording should be limited by the wording that is in the legislative act, so the framework legislation. And yes, so those are the ITS in form of the BTSs can have a 2 form, which in form of the regulated technical standards, that is based on the Article 290 of the treaty, and implementing technical standards on the implementation from the Article 291. Yes, so.
All right. Of course, feel free to ask questions. You know that on the dashboard you can send us questions in a few minutes. Perhaps Joost will join us in order to answer question probably. I don't know if he's coming, but we will be there to answer your questions, and so feel free to send some stuff. So now procedures.
Yeah, now it's the fun part.
Well, great.
So this is the part when everybody is getting, at least me, is getting a little bit surprised by the amount of actors involved and by the length of the procedure. So I would like to talk a little bit more in detail about 2. I would like to talk about the procedure to establish the Delegated Act, and then the binding technical standards, because we also have this implementing act under Article 291, but it's not being used so often, especially in the financial services regulation. So I think it's more important to concentrate on those 2 that are widely spread. So I want to also give an example of how the framework legislation is wording the delegation, to give you a better overview of what to expect. So then, as you see in the Article 27 of MiFID, it's which relates to obligation to execute orders on terms of most favorable to the client. It shows that there is a call for the Commission to adopt Delegated Act. Then it's call on ESMA to develop the draft regulatory technical standard. The time is specified when ESMA has to deliver the technical standard to the Commission. And it's also that the power is delegated to the Commission. The power will be never delegated to the supervisory authorities. As we said, Meroni doctrine is very clear in that respect, that it's not possible that nobody else, that Commission adopts regulation. So, yes, so now we are going to talk a little bit more in details about the delegated acts. So the Delegated Act, I skipped another one. So how does it form? So first maybe that the delegated act is the commission after the granting to the commission the delegation in the framework regulation, the commission calls for the advice to ESA. And then the European Supervisory Committee. And then ESAs prepared the technical advice for the Commission. So they submit the consultation, they draft, they publish the consultation, they meet with the stakeholders, they hold a public hearing. And then they prepare the advice. And the final advice is being sent back to the Commission, which is also provided to the Council and to the Parliament for information. Then, of course, we have this long process of public hearing, public consultation, and then Commission adopts the measure. And this is a very important if we are thinking about lobbying, because that's when we have to influence. You have to try to influence on the technical advice that is being drafted, because that advice is later fueling the thinking of the Commission. And then it's the best point to start on what you actually would like to achieve by the advice. Then, of course, before the Commission adopts the measure, it's good to participate in the public hearings and consultation, because that could also influence in certain aspects what is being adopted by the Commission in the final draft. How the Commission is the delegated acts is formally adopted by the College of Commissioners in form of the Commission regulation or the Commission directive. That's why it's good to distinguish that between the secondary legislation in form of the directive and regulation, because this is not the same act. The act before the framework legislation is being agreed by the Parliament and the Council, so it would state it in the title that is the regulation agreed by the Parliament and the Council. By in this point, when the EC adopts, it's going to be the regulation, the delegated regulation or the delegated directive by the Commission. So this is distinct, and sometimes if you see those two acts, it's good to just always remember that the delegated act will always be the Commission act. It will never be the Parliament and the Council. So then we have the notification is being sent to the two co-legislator, and in this process, because in delegated acts they have a right to veto the delegation or the act and to revoke the delegation. So if the scrutiny, the power to scrutiny the Commission can be is done by the majorities, and so as I said before, by the by the absolute majority of the EP and the Council in the set period of time. So if that's happened, Commission and Commission disagrees, and there was a revocation of the delegation, Commission has a chance to make a new legislative proposal or submit amended draft, and then it notifies the Parliament and the Council again, and it goes through the same procedure. So yes. So what are the crucial points if you wanna lobby of the delegated acts? So as I mentioned before, the ESA's advice, so the consultation and public hearing. Then the Commission can disagree with the advice of the supervisory authority. Then it's also good to keep in mind that you should talk to the Commission, to the desk officers that are being responsible for the drafting. Then Commission is bound to consult and to hear the stakeholders. So participation in the public hearing is also very important. And then it can be that we already know that we don't like something that Commission is going to propose, but we know that, for example, European Parliament, some members of the European Parliament are very concerned about that issue. So then it's we can talk to the members of the European Parliament to make them aware on certain aspects.
All right.
So yes, so this is the easy part. And now this is the implementing act, which is some sort of the comitology, but as I said, it's hardly used to the financial services regulation. Therefore, it's only for information, and I think that we are not going to spend more time on it, as I would like to have some questions from you at the end.
Okay, it's a good. I mean, we already did 30 minutes, so yeah, maybe we can. Do you have to conclude, or you want?
Well, I just have. I think it's also good to mention the binding technical standards, because those are the standards that we see a lot right now, and that are coming from the supervisory authorities. And I think maybe I won't go through the whole process of the technical standards. I'm just going to tell you when it's important to what are the points that are important in this process to pay special attention. So, as task in the framework legislation is preparing the draft and the cost and benefits analysis, and then is consulting the draft with the stakeholders. So this is a good point to be involved, because the stakeholder consultation is probably a good way to be heard. And then we have the technical standards is being finalized and is being sent to the Commission. So the Commission, it's also good to talk to the Commission about how they see, because we can see that it sometimes changes. So certain words can be changed. That was the case of the EMIR, the regulatory technical standards. You probably are very aware of it. How the wording that of two standards were changed, and the Commission amended it, because Commission can amend it, but it has to consult with ESAs, as the supervisors have a better understanding of the financial market, and it caused kind of precedent, because then it came to the Parliament and the Council, and the Parliament were offended by the not enough time that were given, and threatened to use the nuclear option. So it's the objection to the draft, which will result that the draft wouldn't be adopted. And therefore, this is very important to follow on all the levels, and to make sure that we understand all the points where the decision can be changed and can be in the form that is not really favorable to what we achieved in the framework legislation.
All right.
So, thank you very much.
Reaching the end of this. That was heavy for lunch webinar. It's good for digesting. As always, the Finance Watch webinar are good for that. Thanks a lot, Kasia. Basically, I got here a question immediately from Eric. Could you explain if the nuclear option has been used? Maybe repeat this point if...
Well, the nuclear option, there was a thread for using it in the EMIR legislation, and that was the first one. But it hasn't been used, because to use it, it's difficult, because you will have to gather in the Parliament the absolute majority of all its members. Therefore, it's or in the Council the qualified majority, and those majorities are really difficult to achieve. And therefore, it was just used as a threat, but and to show the disapproval from the Parliament side on the process. But yes, it was actually, the nuclear option was at this point never yet used.
Great, great. Another question from Julia: when is the best time to lobby on level 2? I think this you also mentioned, but maybe can you stress one more time, really, when is the best time?
When is the best time to start lobbying? I think that would be still when there is a decision on what form of delegation to use, if we want to use the Delegated Act or Implementing Act, because this would be the time when you can actually influence of what sort of delegation would be put and who will have the responsibility at the end for scrutinizing the act. So sometimes, as I said, it could be a trade-off between the procedure and the scope, because the institution during the negotiation can sometimes decide on something to use, for example, delegated acts, because then a commission has holding the drafting powers, but it can be more scrutinized by the council and the parliament than in the implementing act when the scrutiny goes to the member states. But it's just a trade-off in the legislative process, and it sometimes can be. For example, threatened that the Commission disagrees with the form that is for delegation that is being used, and then it can end up in the European Court of Justice that is only assessing about if the chose form for delegation is the right one. But for sure, you have to start from the framework plan legislation and then start lobbying right after.
All right. Practical question from Nina: will the presentation be available as a PowerPoint sometime or only on video?
Well, we can make it available as a PowerPoint.
Great. Okay. So later on, it will be in our office. Then Camelia, I've seen amendments to text in the Parliament where Delegated Act has been crossed out and Implementing Act inserted instead. Why would MEPs prefer one type of act instead of the other? What are the political implications?
Well, the political implications are in the scrutiny at the end of the in the process, and I think as there are not clear definition why in certain cases the delegated acts is being used and why implementing acts, it's sort of the free political decision of the co-legislator to choose one form or the other, and sometimes it's just a trade-off. They trade the form for something else.
All right. Our question by Isabel on the process. At the very bottom of your slide, you say that EC can adopt a new legislation proposal if the European Parliament and the Council oppose the DA.
It can go as the new legislative proposal. Because if the delegation is being revoked, then it means that there is no more delegation in the framework one legislation. But if Commission thinks that it's important to delegate to legislate on certain issue, it can be that they will, as they have the executive power in proposing legislation, they can come out in the proposal.
Okay, great. So and now we have Stevie sending us a question. To what extent are the ECA's guidelines a prescriptive requirement, particularly when we compare with Delegated Act RTS, which are binding in their entirety?
Yes, so the guidelines are the level 3 process. So we have this one slide which is like in the step form, and it's so the guidelines are only implementing measures and they are non-binding. So they should just enhance. They should just make the understanding better for the supervisors of how to act, but they are non-binding. So they are on the comply or explain principle.
Mm-hmm. All right. We got here, can you talk, so by Gideon, can we talk about member state optionality? I know it is not in the presentation. Is it possible to say something?
Member state optionality?
Yeah.
I'm not really clear about the question, but if I cannot really respond something, I'm happy to respond in writing.
Yeah,
that we can specify.
later on,
Yes,
for sure. Feel free to contact us if you have if you have question later on. Of course, the staff is based in Brussels and ready to answer every question. Camilla, do you have tips on lobbying the ESAs?
ESAs. Yeah, well, lobbying, I think Jost before did the seminar on lobbying that we can actually apply also to lobbying of ESAs. It's for sure it's good to be present and present both in a physical form in the places where ESAs are located, and also respond to the consultation and participate in the public hearings. I would say that would be my best tip to lobby ESA, because they have to know your points and they have to know your the things that you're trying to convey, the messages you're trying to convey.